Just because the evidence disappears doesn't mean the case does. It was a long road to even prove that the medical device that was used in this procedure was this particular Ethicon stapler, because there was no record in the op report. Usually in an operative report, you'll have a lot number or something you can scan and figure out what that device was. That was gone. The stapler was thrown away. And so ultimately how I figured it out was the case was a product case. It was a hybrid case. It was also a medical malpractice case. And so we sued the surgeon at Surgery Center. The cases are won on clarity, right? And that made a very complex, medical device case, and all these engineers and all this language so simple. Like, really? You knew that these are your specifications, that you cannot fire higher than this, but you're not doing anything about it, and your own workers are telling you that? The jury will get it.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we can all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited for this conversation with Nina Shapirshteyn, partner at Abramson Smith Waldsmith LLP, and one of California's most decorated plaintiffs' trial lawyers. You're known for a number of cases, but I think the one that stands out in a lot of people's minds is the Johnson & Johnson verdict that you got. For those who are not familiar, can you help us understand a little bit about what that case was about?
Sure. And, people always want to talk about it. You're right. And I just want to say something to the young lawyers about that. Is in this profession, we define ourselves by our verdicts. And trials that are not won tend to disappear. You see that on plaintiffs' listservs where, there's a trial watch and so is in trial and they're talking about it. And then if they lose, it goes into this ether. I have certainly had cases where I worked just as hard and I felt that I did as good of a job, if not better, as I did in that Johnson & Johnson case, but I lost. And losses are devastating, but they don't erase the good work that we do while trying these cases. And I just wish that we defined ourselves by that work more so than the number on that verdict form. Having said that, of course, verdicts are important. They're important for many reasons, including insurance adjusters and opposing counsel, and how you're viewed going forward as a lawyer and how people negotiate with you, right? That case was, it was obviously, as a lot of our cases are, about accountability. It was a medical device that was used on my client and caused her very serious injury. The medical device was a hemorrhoid stapler. So just like a linear stapler that we use to staple papers, but it was a circular stapler. So there were staples all around a circle.
Okay.
And essentially it would be inserted into the rectum and it would excise a ring of tissue and staple it away.
Okay. So
it's not a necessary medical device. This procedure was performed by surgeons before the stapler, just with, sutures. But it made it easier. It was supposed to make it easier, but it seriously injured my client. So we sued Johnson & Johnson, its subsidiary Ethicon that actually made the stapler, and a couple other subsidiaries for different reasons. The problem with the case was we didn't have the product in this product case, and tends to present a problem that the defense can certainly lean into and say, how are you going to prove your case when you don't have a product? But, because the evidence disappears doesn't mean the case does. So it was a long road to even prove that the medical device that was used in this procedure was this particular Ethicon stapler, because there was no record in the op report. Usually in an operative report, you'll have a lot number or, something you can scan and figure out what that device was. That was gone. The stapler was thrown away. And so ultimately how I figured it out was getting all the packing lists for all the staplers that were shipped to the surgery center, and then comparing that timeline and the particular staplers with all the surgeries that happened at that surgery center and trying to line them up.
You must have had the HIPAA discovery fight of your life.
You would think that, except the case was against, it was a product case. It was a hybrid case. It was also a medical malpractice case. And so we sued the surgeon and the surgery center. And I will say that they were happy to provide information in some regards.
Okay.
Yeah, exactly. Well, point over there. So obviously everything was redacted and properly done. And really we just needed the dates of the surgery to try to line it up and to say that there was any agreement as to what happened, and that just didn't happen. And so we had to tell the jury about all these surgeries, and we had to tell them about all the staplers that were shipped. And ultimately, I guess I proved that it was the one. When I think about that case, and it was a punitive damages case. There was a compensatory damages of about 10 million, and then 70 million was punitive damages. And it was certainly a highlight of my career to argue punitive damages. And I didn't know that I would ever get to do that. And a lot of lawyers don't. And that's when our community of trial lawyers really helps, because I got on a phone, I called Jim Boswick. Jim Boswick obviously is one of the best lawyers in the nation. He put me in touch with someone in, I want to say, Arizona, who argued punitive damages, and we just talked for an hour. And that was wonderful. I really do love our community and how we're there for each other when need be. So when you think of punitive damages cases and product cases, we're taught we're going to take all the apex depositions and get the executives and prove that there was knowledge, right, and a cover up, and certainly that is very exciting, and you want to do that. But in that particular case, what I think was very impactful is I went down the chain because what was wrong with the stapler was, if you staple a bunch of papers together, a lot of things can go wrong, right? And then you got the staple that's not fully formed, so a lot of things can go wrong. And now you're doing that inside a person.
Yeah.
And that's a lot of things can go wrong there. So what Ethicon knew was that there had to be a particular force to fire that cannot be exceeded, right? Because if it's really difficult for a surgeon to fire a stapler, what are they going to do? What do you do when you can't staple?
You bang on it.
You do it again,
yeah.
Right? And that's what was happening. So we didn't have the stapler, but we could show through testimony of the nurses, the tech, the experts, the doctor, that it was difficult to fire it. There was some issue. And when I started deposing the subject matter experts, right, the engineers from the company, from the manufacturer, there was this party line of, we had control measures, right? So control measures, this language that is used, and control measures meaning what were they doing? They were measuring the force to fire of these staplers, as you should, because it can't exceed a certain. So I took the deposition of an assembly line manager. I came very close to going to the assembly line, but that ultimately wasn't necessary. So, and this assembly line manager, he says, yeah, the assembly workers measure this force to fire for every single stapler, and there's a record of it. I said, okay, what do you do when the force to fire is too high? Have you ever thrown out any staplers? No. I'm sorry. You're measuring the force to fire, but then you don't do anything with the measurements. I said, did that seem strange to you? Well, why are you wasting your time on these measurements if you're not doing anything with them? Did it ever occur to you that that was weird? And he said, this assembly line worker, this woman came up to me one day and said, why are we doing this? I'm spending this time firing these staplers and measuring the force to fire, but we're not doing anything with them. And that was for me this gasp, this moment of, if she could understand it, the jury is going to understand it, because the cases are won on clarity, right? And that made a very complex, medical device case, and all these engineers and all this language so simple. Like, really? You knew that these are your specifications, that you cannot fire higher than this, but you're not doing anything about it, and your own workers are telling you that? The jury will get it. Some of the lessons I'll tell you I learned from that case, not just as a lawyer, but as a judge later on, was obviously I had prior other similar incidents, right? So they were complaints that the manufacturer had received. These complaints were usually from the surgeons, and, from all over the world, that it was difficult to fire. And I remember taking the deposition, and it was like a 4-day deposition of their PMQ. And I was going through every complaint and asking, on such and such date, Ethicon learned that XYZ happened. And even, I think, the lawyer who didn't represent the manufacturer said, are we really doing this with every complaint? And I said, we're really doing it with every complaint. So then this video is being shown to the jury, and after maybe a day of it, we get a juror note, and it says, after all these complaints, does J&J, does Johnson & Johnson really want to go on? Why are we here, essentially? And boy, did that back. I mean, at first, obviously, as a trial lawyer, my reaction was, oh, yes, this is great.
Yeah.
Well, I think there was a motion for mistrial or whatever it was. But ultimately, that was a huge point on appeal.
Okay.
Right, because this juror made up her mind. And,
I see.
And I used to like questions from jurors because you get a window into what they're thinking. I can maybe reshape my case, my questioning based on that. I know what I need to prove, what what I didn't think about. And after that, I said, I never want to see that again because that is such a can of worms.
Were you able to preserve the case on appeal?
Yes. So, certainly the juror note wasn't ultimately a big deal. The Court of Appeal didn't care about it that much, but the verdict was reduced slightly, the punitive damages, even though, I stayed within, and I asked for $70 million, which was 1%, under 1% of the net worth and all that. And by the way, the jury said, we only gave that money because that's what you asked for. We would have given basically anything you asked for. And that was another lesson that I learned from that case is I wouldn't have asked for more because you're limited on punitive damages, right? But on compensatory damages, I would have asked for more. And, this was also back in the day. The verdicts that have been coming out now are much, much higher
Yeah.
in many cases in LA, especially. So,
Yeah.
I'll tell you a funny story about that case. So, I didn't get 998 costs.
Because
You're like, was your 998 more than $80 million? No. No, it was not. I was so diligent with that 998 offer. Wanted to make sure to lay out everything that was known by that stage of litigation. And I laid it all out. And so the argument from opposing counsel was that it was not reasonable for them to accept the 998 because it would signal that they're admitting all these things.
because it was in the body of the 998.
It was in the body of the 998, but it was phrased as what plaintiff believed
I see.
they had. So anyway, since then, I keep my 998s very sterile. And then I send the letter with the 998, laying out what is known to the other side.
That is, of the various wisdom that has come forward, 998s are always, I feel like every year when I sit down to listen to what's new in tort and trial, there are always cases on 998s.
Yep. Mm-hmm.
There's not a case on that, as far as I'm aware, and that is a fabulous pointer.
Yeah, that was, I just think it is so funny that I managed to not get my 998 costs on an $80 million verdict.
Yeah. Any other clutch points, wisdom that you'd want to share from that particular case?
There was a whole binder of complaints that we did not, for reasons that aren't important now, that we weren't able to get in our case. And opposing counsel was very happy about it, obviously. In her direct examination of her witness, she goes too far and she starts talking about, oh, well, you reviewed this and you didn't see this in the complaints. So I get up and I take this binder and I go, these are the complaints you reviewed, right? Obviously, the door, she just opened the door, swung it wide open.
Wow.
And opposing counsel goes, Your Honor, this is our case. And this was just one of the example, not really a teaching moment for me, but it kind of like you have to be so aware with your own witnesses. You get so comfortable because you know that they will say anything you want them to say, right? And so, and she went too far with this witness and opened the door, and there was another binder of complaints that I would have never gotten in.
Yeah. I think both important in terms of learning what not to do when you're questioning a witness, and also being quick on your feet to be aware that they have opened the door for you.
I just remember I jumped up. It was so exciting.
Did you get a nod from the judge? Like it's go time. You got that.
I believe so. There were a few. We had a great judge too. She was very smart.
Yeah.
She is very smart. She's on a court of appeal now.
Well, as we kind of come into the final moments, are there other things you would want to share with our listeners?
One of the important lessons I learned early on, that there's that saying, dress for the job you want, not the job you have. That in trial, it's the opposite of that. You try the case that you have, not the one you wish you had. Which means deal with the facts, the bad facts, the good, the bad, and the ugly, right? And face them head on, because too many times and it's not just wishing the bad facts away, but you've lived with a case for a while. And so you know the truth, and your client is really injured. And you just forget that the jury doesn't know that they haven't lived with this case for 3 years. And they need to put things in perspective and understand why your client is injured, even though, this was a 3-mile-an-hour hit, and she had pre-existing back injuries and so forth. So you believe your client, and you need to explain to the jury why you believe your client, because there's no reason that they should. They haven't lived with it for 3 years. So I would say that the biggest thing is, the biggest advice is that I can give is to face the bad facts and organize them in such a way that the jury understands them just like you do. And as far as what I can take from being on the bench and being a lawyer, well, being a lawyer, then being on the bench, then being a lawyer again. It was such, by the way, an incredible experience. And it was kind of like watching everything 30,000 feet, having almost an out-of-body experience, right? You're up there and you're getting to observe, and you see so much more than you see as a lawyer. When I started practicing, the advice that was very popular was tell him, and then tell him what you told him, and then tell him again, or something like that,
Yeah,
right?
I remember that.
And I'll say that is no longer the case. Because I think because we have this instant gratification mindset from social media, from being able to GPS something and get somewhere, right? Everything is so quick for us in this world that the jury doesn't want you to explain things over and over. They're also very smart. So probably everything that we do in front of a jury can be cut, 70%.
Okay.
Be short and sweet, and they will get it.
I guess the follow-up question that I have is, do you know what 70% to cut?
Well, yeah, cut repetition.
Yeah.
If you can't explain your case in simple ways, then you don't understand your case. So you have to get to the point where you can explain it in simple terms the way you would to a non-lawyer. I don't want to say a 12-year-old, because they find that what people say that's offensive to the jurors who are very smart. What I found was that jurors don't want to be there initially. We all know that. But they also tend to appreciate our system once they're done with the jury duty, and they are grateful for it. As a judge, what the mentality that I had towards what I was doing there was, it was like selling a product. And the product I was selling was justice. And everyone was my customer. It was the lawyers in the courtroom, the jurors, observers, witnesses. And it was very important to me to have them believe in the rule of law the way I believed in the rule of law when I moved here and when I saw how this country functioned. As lawyers, when we're in the courtroom, especially when there's a jury, especially when there are witnesses, or anyone watching, we have to remember that we are the officers of the court, that we represent the system of justice. And you are the face. We say this to corporate representative, you're the face of the company. As lawyers, we are the face of this justice system. And if there are lawyers who are calling each other names or are being rude to witnesses or yelling or being disrespectful, that's the experience that jury is going to have, and that's how they're going to view our justice system. That was a different perspective for me watching it from the bench. And I did feel that the civility in the courtroom is declining, and we have to work really hard to change the public perception so that people believe in the rule of law again.
That seems particularly challenging when the commander-in-chief is using F words in tweets related to diplomacy?
It's been very discouraging for me on many levels, as a woman, as a mother, as a Ukrainian. When in 2022, when the war with Russia started, I guess it started in 2014 with Crimea, but in 2022, when Russian troops entered Ukraine and this country was up in arms and really helping. Again, I found myself a proud American. And now, of course, our commander-in-chief president seems to favor dictators over democratic leaders, and that's very discouraging. And sometimes when you watch the news, you feel so helpless, right? And so what do you do about it? And it's, I don't have the answer for it, but I get my hope from countries like Hungary right now. And we do it, one step at a time, and you can at least control your actions as a lawyer and how you're perceived, and we can't lose hope.
When I get the impression, and you can correct me if I'm wrong, is the way that you channel anger or quiet rage is into your cases and into your work.
That's true. I have to say that I've always worked best under pressure. And that might be, again, from the type of education that I received. And I embrace it. And, I don't really get angry anymore. And being on the bench was almost like a meditation experience, because I couldn't allow myself to show anger or disappointment or, it was a different type of responsibility. But there's nothing wrong with taking anger and using it to your advantage in your work and being fueled by it, just as long as you keep your civility, right? And be a good person and stay kind.
Yeah. Was there anything else that you think we should touch on?
I'll say I am really excited about this new chapter in my life. I finally get to practice law the way I want to, how I want to, with the people I want to. My partners are my friends. They certainly are exceptional lawyers, but they're also my friends. And so we really enjoy talking about cases, working on cases together. RJ Waldsmith and Jeff Smith that will, get together not to talk about work. And then we end up doing that and having a great time. And it's very refreshing.
You certainly landed on your feet at a very good place.
I've been very lucky in my career with most people I worked with. There is one thing I will say. You asked about advice for young lawyers. A lawyer told me once before trial, the facts are what they are and evidence is what it's going to be, essentially. And then the jury will decide. And I remember that, and I remember thinking, well, why are you here? Why are we here? Why don't we just give the jury a stack of documents and transcripts to read, and then they'll figure it out? Such a huge part of what we do is taking the facts and organizing them in a manner that is easy for the jury to understand, right? That concept of argue the facts. It is so important how the facts come in, how they trickle in. That's the fun part about being a lawyer, is telling a story. How do I, there are 100,000 ways of telling the story. What is the best one? And it really matters.
Yeah. Well, I look forward to seeing how you tell those next stories and next chapters in the trials to come. So welcome back to this side of the bench.
Happy to be here.
Yeah.
Thank you.
And thanks for coming on the show.
Thank you. It's been a pleasure.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.